Good afternoon, everyone, or is it morning? It's almost afternoon. Today is Friday the 13th, February the 13th, 2026, and my name's Wendy, and this is Truly Sinister. Anything true crime or anything legal, basically, is what we do here. I hope everybody's ready for Valentine's Day. I hope everybody's taking care of their sweethearts and thinking of them. And don't forget to go, you don't have to buy anything big for them. Just maybe a rose or a card, or just do something to show them how much they mean to you and how special they are in your life. It doesn't have to be expensive, it just has to mean something. That's all it has to do. So, cook them dinner. And if you always cook, then take them out to dinner. Do something a little different, but it just has to show them that you love them and you're thinking about them on this special day. It doesn't have to be expensive and fancy. To each his own. Just let them know that you're thinking about them on that day, and I'm sure they'll be thrilled. Sorry, I haven't been on for a while. We've been having some excitement around here. My husband, well, he races BMX, and he raced all weekend 2 weekends ago and survived. And I say that jokingly, but he's getting up there. We're both getting up there in years, so I told him the main thing is you have to be able to work on Monday. Do what you want, but you got to be able to work. Well, he made it through the weekend, and he hasn't been racing for a couple years now because he got really sick right before COVID, and so he's been really, really battling back. And so he finally raced that weekend, and he didn't do great, but he did as well as could be expected. He's been training and stuff, but it takes a while to get back on it, and made it through the weekend fine. And then 2 days later, he went over to the track, which is the BMX track is right by our house, and came home really quick, and I was surprised. And he said he looped out, he slipped a pedal. So yeah, broke his arm or broke his wrist. The orthopedic surgeon said he pulverized it, so they don't know if they're even going to be able to put screws in it. They're probably going to have to plate it. So he won't even be able to, bend it or anything for at least 3 months. And then they have to go back in and remove the plate once the bones fuse. And then he has to go through rigorous PT, physical therapy, because he will not be able to bend his wrist or rotate it or anything for 3 months. So he's going to have to relearn how to use it and get it mobile again. And of course he broke some ribs, and of course he's irritated because he's got some big race coming up in June that he goes to every year. It's called the Dirty Fest down south, Southern California. And it's one of his best friends' race, and it's like an old school race. I mean, not old school race where they don't use clip-ins and whatever, but they have bike shows and everything. It's a big deal. And he was going to race it this year, so now he told me he's going to race no matter what. We'll see. I'm definitely not going to support that if he's still incapacitated, because I don't need him to be even more broken. But so yeah, so we've been running around between my working and him, that was 9 days ago. So we've been busy. He's been in a lot of pain. And so today he's having surgery. I just dropped him off. They were going to take him in at 11. The nurse called me and said they just took him in. It's going to be about maybe a 90-minute surgery, if not a little longer, because they're not really sure how they're going to, work this. They said that there's really no place to put screws because it's so pulverized and just kind of powdery, the end of his um, ulna and radius. So they're going to have to get in there and look at it before they can really tell us what they're going to do. But he may even have the external, how they have the halos for head injuries and neck injuries. They also have that kind of stuff for, wrists and legs. And he might come home with that. And he was not thrilled to hear about that. He was in a lot of pain, though. So I think anything, he was willing to just agree to just about anything at that point. He was in a lot of pain when I left. So I thought I'd come home and touch base with the channel and do a quick video on some updates. Kelsey Fitzsimmons had another victory, and it's about time because it's well deserved, let me tell you. She needs to be out of this debacle, and she needs to be able to focus on getting her son back. And that's all she needs to be worried about right now. But instead, she's, dealing with her criminal case, which, I mean, if she's found guilty, she will be on probation anyway. She won't even get jail time. So it's like lingering longer than what she'd probably even be on probation for at this point. But we need to clear her name. And I understand she wants to clear her name, if she ever wants to work in law enforcement again, especially. That was her dream. Obviously not in Andover. I hope she moves far away from there. Obviously she's going to have to work something out with Justin because they're going to be co-parenting. But yeah, she doesn't need to be anywhere around that town or that area as far as I'm concerned. But yeah, so she had some good news in the last few days. They have a tentative uh, court date or trial date for Aaron Spencer, so we're going to go over that. And then I was going to go over the first couple weeks of the Alexander brothers trial and how that's going in New York in the federal courts. Just pure scum. They've had quite a few witnesses testify already. Apparently, the latest drop of shocking news was the brothers were mentioned in the latest Epstein dump. Yeah. So they made it onto the into the Epstein files, if you can believe that. I mean, what the fuck, right? I mean, it's like, what? I don't know why it surprises me. It really shouldn't. I mean, they're in that same level of perversion and disgusting behavior that Epstein was. So why is that so surprising? I have no idea. They're from the same area, the same, level of wealth, and, why not? As far as they're concerned, it's just like being in an old man's club, like a gentleman's club or something for them. It's disgusting. So, yeah. So now their lawyers are worried about, prejudice against the jury or with the jury. And, I think they take care of that themselves. I think that if the jury is found to be a little bit prejudiced against them, I think that's of their own doing and the behavior that they have, partaken in the last decade. I think that they've handled that just fine. So I don't think there needs to be any kind of outsourced prejudice. So I don't know what's going to happen with that, but their lawyers are very, 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 very concerned that that it's going to affect them getting a fair trial. And I'm here to tell you that I don't care what comes out or what doesn't come out. They're scum. They're low lives, they're animals, they're monsters. And I don't think being in any kind of file or on any kind of list is going to make them look any worse than they do by themselves. So there's that. So yeah, so we're going to get right into it because I don't know when his doctor's going to call me and I'll have to leave. So I don't want to have to leave in the middle of a live. I don't do a lot of lives, so I'm hoping that it goes smoothly. Otherwise, it won't be listed in my live uh, videos. It'll be listed in my videos so that I can do a lot of editing. So wish me luck. I hope this goes well for you as well as me. And let's get started, shall we? First, we're going to go over the good news, the Kelsey Fitzsimmons motion. Tim Bradel filed a motion to have the judge recuse herself. You know, Judge Kathleen McCarthy Nyman is a piece of work, and if you don't know about her, then you need to watch some of Melanie Little actually bought the audio of a hearing that they had where she just lost her shit. I mean, she was visibly shaking. She was so angry, and it was just so unprofessional, so ugly. I mean, it was just not becoming of a judge in any situation. But she showed her hand that day, and she has just been picking Kelsey Fitzsimmons apart little by little, just trying to break her down. And I don't know why. I don't know if she's got, some kind of personal tie to, one of the officers. Officer Neiman is McCarthy Neiman, I believe. Or Noonan. I don't know if they're related. I don't know. But she seems to have some kind of personal she's invested personally in this case for some reason, or it appears that she is, and that's all it takes is the appearance of lack of impartiality. And I would say that it appears very much so that cannot be impartial in this case, and she needs to step the fuck off already. I mean, she is just something else. And to find out some of the things that she's done, Timothy Bradel brings it all up in his motion, and it's disgusting to think that a judge serving on the bench in today's day and age would behave like this. It's just, I mean, and in Massachusetts, nothing surprises me anymore, but this surprised me. I mean, Judge Canoni had her moments, I mean, she had her moments. The whole trial was a moment for her. But at least she was disgusting openly, and she just was not impartial, and she was very biased, and she made it clear, and she just made it clear that she didn't like Karen Reed or Alan Jackson. She just didn't like him. And it was known, and whether or not that's fair, I guess it really doesn't matter because, Alan Jackson filed a motion for her to recuse herself, and she heard the motion herself, and she denied it. Said she was not going to do so, and I guess that is her choice if she's the one hearing the motion. But those are my dogs, so you'll have to excuse the background noise. Just 1 second. Sorry, she is like a demon seed. I mean, she's Satan's spawn if I've ever seen it. She's just like a little firecracker. It kills me. But anyway, yeah, so, but this judge, is a whole nother level of bitch, I guess is the only way I can describe her. She's just, and it's becoming painfully obvious that it's the female judges more than anything that are just, it's like they have an axe to grind. They're going to die on their cross if, come hell or high water. And it's like, who the fuck are you trying to impress? Because you look like a complete asshole. Between Judge Cannoni, this new judge that I've been watching the Georgia versus Edric Faust case. He's on trial for murder, and the judge in that, Lisa Lott, she doesn't even wear a fucking judge's robe. What the hell? That is so disrespectful to the justice system, I think. It's like she's, turning her nose up at them, saying, I'll wear what I want, and that's not good enough for me. Well, you know what? Then step off the bench, bitch. I mean, she's a whole nother level too. It's just, I'm finding that it's the women judges mostly that are just unbearable. I mean, they are so angry, and it's disgusting the way they carry themselves in the courtroom, as far as I'm concerned. And Lisa Lott, she was a defense attorney for years. And to see her behave the way she has towards this defendant and the defense attorney, it's so obvious that she's biased. It was another case like Karen Reed's. The prosecution spent the whole trial defending her ex-boyfriend rather than prosecuting the defendant. They never showed any evidence to even give a reason why they were able to prosecute him, much less convict him. It's disgusting. It's like they spent the whole trial defending her ex-boyfriend. And now this Kathleen McCarthy Neiman, it's just disgusting. So anyway, if you're not familiar with the Kelsey Fitzsimmons case, there's a lot of videos and literature about it. Anyway, she was an Andover police officer who was out on maternity leave, and she lived with her boyfriend Justin. They had a baby boy. She suffered not only postpartum depression, but postpartum psychosis, which is a thing, whether people... And so she was just getting back on her feet. She just got cleared to go back to work. She got her gun back. She got her badge back. She was scheduled to go back to work July 4th. In fact, she found that out the day of the incident. But, the weekend before that, I believe June 28th or something, they had a bachelorette weekend in Maine, somewhere in Maine, where, the bride and groom, Justin and Kelsey, both invited friends. And they had a mixed bachelorette weekend, for the bride and groom. And she got drunk like many brides-to-be do. I mean, that's what you do at a bachelorette party, right? If your fiance's there, or your future husband's there with you, you're not going to have strippers. So anyway, apparently they got in some big argument, and she allegedly hit him. Okay. Well, they lived together in her home that she owns with the baby. They lived as a family. Well, Monday, Justin, ex parte, went to the court, filed for a restraining order, filed for, emergency custody of the baby, said that he's afraid she's going to hurt herself, the baby, and even him. And he was in fear. And, and while he's at the court doing this, he had set up a meeting with her at some park. He said, bring the baby, let's talk, we'll meet at this park. Okay, well, she takes the baby and she waits at this park for like 3 hours. He doesn't show up. Well, no, because he wanted her to be busy doing something while he's in the court filing for a restraining order and emergency custody, right? And he even had a friend of his watching her and keeping him apprised of where she's at, what she's doing, so that he knew that he was in the clear and had time to pull this off. So anyway, after he didn't show up, she goes home. She's sitting on the couch in the evening, breastfeeding the baby. There's a knock on the door. And she opens the door, and it's 3 of her coworkers, one being her partner, Noonan. Okay? And this is the same day she got her badge and her gun back. Was told that she was going to go back to work on July 4th, which is just in a few days. They came over and served her with the restraining order. Okay. No mental health advocate for her with them. Nobody. Just 3 officers, co-workers of hers. And she's got the baby in her arms when she answers the door. Then they tell her that, oh, we're here to get the baby too. Justin will be here any minute to pick up the baby. Oh, and we need your gun and your badge. You are no longer an Andover police officer. So in a matter of, 3 minutes, she's lost everything. At least she feels like she has. I mean, it's like getting punched in the solar plexus, She had to have just been like totally blindsided by this, and it's just a shitty thing to do. And I can't imagine that a court would do this without hearing both sides. You know what I mean? Obviously, he doesn't truly believe what he's saying about her harming the baby, because where's the baby at while he's in court applying for this restraining order? The baby's with her. But they didn't hear her side. They just granted his requests. So she's packing up, getting baby stuff together for the baby, and she tells them, keep Justin away from me. So Justin's told to stay in the basement. And they ask her where her guns are, and she says they're in a safe in the basement. Her mom shows up, I believe, and she says she has to go upstairs and pack some stuff for the baby. So Noonan, her ex-partner, or her partner, not even her ex-partner, her partner, goes upstairs with her, while one officer stays in the basement with Justin, and the other one's on the first floor. Now, this is where the stories differ. Noonan says that while Kelsey was seated on the floor with her legs crossed, folding baby clothes to put in a bag for the baby, she lunged behind the bedroom door and came back with a gun, pointed it at him, and he shot her in the chest. 2 shots. I don't know where the first one went, but the second one hit her point blank range in the chest. Okay? And she's a tiny thing. Her story is that she got the gun, pointed it at her head, wanting to, unalive herself, pulled the trigger, it didn't fire, and when she went to reload or try to, re-rack the bullet or whatever they say, he shot her. Okay, well, my thing is, and there's always 3 sides to the story, his, hers, and the truth. But the thing is on Zillow, you can do a virtual walkthrough of her home, because, of course, she's had to sell the home to help pay for her legal fees now. But anyway, there are no doors on the bedrooms in this house. They're all open rooms. There's no doors on the bathroom. There's no doors on the closets. There's no doors on the bedroom. So how did she lunge behind a door? A. B, if she's seated on the floor with her legs crossed, how did she lunge, period? You can't lunge off your ass, right? I mean, that's pretty impossible to do. They were in while she was pregnant, she and Noonan experienced a tragedy together. They were called to a scene where a mother killed her baby and herself. And I think Noonan had PTSD from that, because they weren't offered any kind of psychological help after that, apparently. They were left to deal with it on their own. And she was pregnant. And I think that came back to haunt him that day with Kelsey, and he panicked and he shot her. The police officer that was on the first floor, when a cop is holding you at gunpoint and you're pointing the gun at them, what do they usually say? Drop it. Right? Drop it. He didn't say that. All he said was, don't do it, Kelsey, don't do it. So what does that sound like to you? To me, that sounds like she was going to hurt herself. But you're telling me that he, at point blank range, he couldn't shoot her in the leg or the arm or something? He had to shoot her in the chest? She was life flighted to the hospital. She spent, what, 5 months in the hospital, had something like 8 surgeries. She had a lacerated liver. Her kidneys were damaged. Chest tube, tension hemothorax, which means your lung is popped and it's full of blood, which is a pretty quick way to die. She is so lucky to be alive. She still has bullet fragments in her back. Okay. And they arrest her in the hospital, handcuff her to the bed. They arraign her in her hospital bed. So this is the story of Kelsey Fitzsimmons. So now she's on trial, but you know how they say that a good prosecutor can indict a ham sandwich in front of the grand jury, right? Well, then she must really be innocent, factually innocent, because the grand jury, the only indictment they handed down was for an assault with a dangerous weapon. They didn't hand down the requested attempted murder or manslaughter or whatever, attempted murder. They didn't hand any of that down. They just handed down an indictment for assault with a dangerous weapon, which, seen as though she's got no criminal background, she would be, if she's found guilty, she would be put on probation for maybe a year. That's, it's not, it's serious, obviously, but yeah. So the grand jury doesn't even think that she is guilty of attempted murder. But this judge has a true hard-on for Kelsey, and you'll see what I'm talking about when we read through Tim Bradle's motion here. It's 15 pages, so we may not get through all the updates today or in this session, but if not, I will record a video finishing up tonight and then post it tonight so that you don't have to wait for me to go live again. Because you know how men are when they're hurt or sick, and when he gets home, I'm probably not going to be very available. And I don't mean anything bad towards men, but let's be realistic, shall we? It is what it is, right? So let's get going, shall we? Okay. Nope, I don't want that. There. So can you guys see that good? Okay. So this is Essex Superior Court, Commonwealth v. Kelsey Fitzsimmons. Defendant's motion to recuse Judge Kathleen McCarthy Nyman and request for evidentiary hearing. Introduction. Now comes the defendant, Kelsey Fitzsimmons, by and through counsel, and hereby files the instant motion to recuse Judge Kathleen McCarthy Nyman. As grounds, it is apparent that a reasonable, disinterested observer, being apprised of the facts of the judge's involvement in the case, would conclude that there is a lack of impartiality, or at a bare minimum, an appearance that the judge's impartiality might reasonably be questioned. And I would have to agree with that. The instant motion is made pursuant to the Due Process Clause of the 14th Amendment of the United States Constitution. Article 29 of the Massachusetts Constitution, Declaration of Rights, the provisions of the Supreme Judicial Court's Code of Judicial Conduct, and applicable case law. Sorry, I worked all night and I haven't slept yet. All of which mandate disqualification when a judge cannot be fair or impartial, or where her impartiality might reasonably be questioned by a disinterested third party. Here, the record demonstrates multiple grounds, each independently sufficient and collectively dispositive, requiring recusal. Request for evidentiary hearing. As the body of evidence required to be amassed in support of the motion likely includes, but is not limited to, probation officials, municipal third-party records, social media information, and the like, an evidentiary hearing and its attendant subpoena power is necessary to introduce the evidence and make sure the record is clear. Applicable standard. A judge must disqualify himself in any proceeding in which a reasonable person, knowing all the circumstances, would question the judge's impartiality. The inquiry does not turn on the judge's subjective belief in his own neutrality, nor does it require a showing of actual bias. This principle of impartial justice is enshrined in Article 29 of the Massachusetts Constitution Declaration of Rights. It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice. It is the right of every citizen to be tried by judges as free, impartial, and independent as the lot of humanity will admit. Quote, a rigid adherence to that principle is essential to the maintenance of free institutions. It may never be relaxed, end quote. In fact, litigants and visitors to the Supreme Judicial Court at the John Adams Courthouse in Boston are greeted with one legal principle to the exclusion of all others in the vestibule, the words of Article 29. The protection of an accused's right to an impartial adjudicator is prominent in both the United States and Massachusetts constitutions. It is axiomatic that a fair trial in a fair tribunal is a basic requirement of due process. Quote, actual impartiality alone is not enough. Our decisions and those of the Supreme Judicial have commented often and in a variety of contexts on the importance of maintaining not only fairness, but also the appearance of fairness in every judicial proceeding, end quote. In other words, an accused's constitutional right to due process demands that, quote, justice satisfy the appearance of justice, end quote. In ruling on a motion seeking recusal for an actual, apparent, or potential transgression of Article 29 and the Code of Judicial Conduct, a judge must, quote, consult first his own emotions and conscience. If he passes the internal test of freedom from disabling prejudice, he must next attempt an objective appraisal of whether this is a proceeding in which his impartiality might reasonably be questioned, end quote. If the answer is positive, the judge must grant the recusal motion regardless of such consequences as trial delay, which are immaterial. See Code of Judicial Conduct. Quote, a judge shall disqualify himself or herself in a proceeding in which the judge's impartiality might reasonably be questioned, end quote. A judge is disqualified from any matter if the judge cannot satisfy both the subjective and the objective standard. The subjective standard requires disqualification if the judge concludes that he or she cannot be impartial. The objective standard requires disqualification whenever the judge's impartiality might reasonably be questioned by a fully informed, disinterested observer, regardless of whether any of the specific provisions of paragraph A1 through 5 apply. Specific, non-exhaustive examples of bias. The standard focuses on public confidence in the integrity of the judicial process before the court. Recusal is required where a judge has a personal or economic interest that could be substantially affected by the outcome, has engaged in an ex parte communications concerning a pending matter, has become personally embroiled with parties, counsel, or witnesses, or has taken actions that viewed cumulatively undermine the appearance of impartial adjudication. All of these recusal categories are present in this case. Yeah. It's pretty crazy, if you ask me. Just one second. Procedural background relative to recusal. Ms. Fitzsimmons is before the Essex Superior Court sitting at Salem in a one-count prosecution charging assault by means of a dangerous weapon. Judge McCarthy Neiman presided on the case on August 14, 2025 for a bail petition in Essex Superior Court. On August 28, 2025 for arraignment, September 9, 2025 for a bail hearing, and September 11, 2025 for an emergency motion for immediate relief from Scram. On both August 14, 2025 and on August 28, 2025, Judge McCarthy Neiman was assigned to, quote, Salem Civil A, Courtroom H, end quote, handling civil business in Salem Superior Court. See Judicial Assignment Sheet for August 2025, attached as Exhibit 1. Nonetheless, she appeared and handled both the bail petition and the arraignment in the criminal session without any verbal or written explanation in court or on the docket. The assignment sheet for September 2025, attached as Exhibit 2, also reflects her assignment to the same civil session. Nonetheless, she continued to leave the civil session and handle criminal business in Ms. Fitzsimmons' case, still without explanation. Without notice to the parties or the public, it appears she has specially assigned herself to this case, a one-count, simple 2 or 3 day trial. Warrants only a sentencing guideline sentence of straight probation. The assignment seems inexplicable on the merits of the case and raises questions about the motive of the court so as to undermine the public's confidence in the ongoing adjudication. Grounds for recusal. 1. Roman numeral 1. Prejudgment reflected in a dangerousness finding and other pretrial matters. In upholding prior dangerousness findings and herself finding Ms. Fitzsimmons dangerous under Statute 58A, the judge has been privy to and has adopted as fact evidence that would not come into a trial of the underlying charge. The court has made a subjective personal finding that Ms. Fitzsimmons is a dangerous person. She has repeatedly referenced her belief necessarily by clear and convincing evidence that Ms. Fitzsimmons is an ongoing and present danger to her assailant, Officer Noonan, who needs the protection of a dangerousness finding from her. The court has also gone so far as to explicitly prevent any potentially favorable family court custody or visitation orders by prohibiting Ms. Fitzsimmons from seeing her infant child, regardless of any custody determinations in that court. This is a highly unusual finding, unprecedented in undersigned counsel's experience, that a superior court judge would impair the family court in performing its own core function of determining custody and visitation in the first instance. This court has gone far out of its lane in an effort to keep Ms. Fitzsimmons from her infant. The court's findings in these areas amount to an expression of her opinion on the character and guilt of the defendant. There are several relevant legal guideposts for the proposition that a judge who makes adverse pretrial findings on a case should avoid sitting as the trial judge. The trial court's findings that the defendant was untruthful in the past and its failure to recuse at the jury trial was found to be an abuse of decision by the appeals court. The appeals court found, and that's in some case, I don't know how to pronounce it, of 1992. His actions constituted error because if, after applying the two-part test of SJC Rule 309, Canon 3C1, a judge finds that he should disqualify himself under either part, he must allow the motion. Disqualify himself under either part. He must allow the motion. Possible consequences of his recusal on the commencement of the trial are immaterial. Further, a judge cannot partially recuse himself. Once a judge concludes that there are grounds for recusal, he must completely dissociate himself from participating in the case. Ordering a jury trial, as the judge did here, does not substitute for allowance of a recusal motion. Even if he is not the fact finder, a judge presiding at a jury trial performs important functions. The judge's role at any trial is to be, quote, the directing and controlling mind at the trial, and not a mere functionary to preserve order and lend ceremonial dignity to the proceedings, end quote. Obviously, during the course of a jury trial, a judge, by exercising his discretion on various matters, makes important decisions which may affect the verdicts returned by the jury. Therefore, a courtroom has no place for a judge whose impartiality in a matter may be reasonably questioned, even if he is not the fact finder. We vacate the judgment and remand the case to the housing court for a new trial. In parento, the court's pretrial findings regarding untruthfulness of a party were dispositive for recusal from the trial, and selection of a jury trial was not a remedy. The foregoing findings against Ms. Fitzsimmons are equally dispositive for recusal and are further supported by the present court's comments against counsel. Here in its order, dated September 16, 2025, document number 19, this court has alleged that defense counsel did not, quote, transparently provide information, end quote, resulting in a, quote, manipulation, end quote, of the court relative to defendant's physical condition. First footnote. The defense believes the court possesses extrajudicial ex parte information that is speculative, misleading, or incomplete that drives this assertion. In any event, no such extrajudicial information has been disclosed by the court, nor has there been an opportunity for the defense to respond, which is required by the Code of Judicial Conduct. The defense denies the claim and has not had any opportunity to address it. In any event, the court's personal conclusion in this regard gives the appearance as well as the actuality of partiality on the part of the court requiring recusal, as was the case in parento. Any other result would be an abuse of discretion. Comment 3 to Rule 2.6 of the Code of Judicial Conduct also addresses similar circumstances where a judge is exposed to settlement or plea discussions and states, judges must be mindful of the effect settlement or plea discussions can have not only on their objectivity and impartiality, but also on the appearance of their objectivity and impartiality. Despite a judge's best efforts, there may be instances when information obtained during such discussions could influence a judge's decision-making during trial, and in such instances, the judge should consider whether disqualification may be appropriate. Adverse findings in a 58A context involve the same negative connotations as partiality against defense counsel, plea, or settlement discussions, and should be included in the same calculus for a sitting judge on both the subjective and objective prongs as to whether an appearance of bias exists. Similarly, the reporter's notes to Mass R. Crim P30 relating to post-conviction relief address whether the trial judge who presided over a defendant's conviction should continue on the matter. While in the first instance, the case should start with the trial judge, the trial judge may bring to the hearing a prejudice that another judge would not have. Recusal of the trial judge should thus be liberally exercised, particularly where it is requested by the moving party. Reporter's notes to Mass R. Crim P30. Thus, the rule recognizes that prior findings and proceedings can taint objectivity and that recusal should be liberally exercised, especially when the moving party requests it. The court's prior findings relative to the character and fitness of the defendant as a mother, as well as the court's criticism of defense counsel, conclusively demonstrate that the court's objectivity is tainted, warranting recusal. Finally, the court's demeanor and actions at the September 11, 2025 pretrial hearing also provide ample grounds for recusal. Rule 2.3 of the Code of Judicial Conduct, Comment 1 provides, a judge who manifests bias or prejudice or engages in harassment in a proceeding impairs the fairness of the proceeding and brings the judiciary into disrepute. A judge must avoid words or conduct that may reasonably be perceived as manifesting bias or prejudice or engaging in harassment. The recording of the hearing accurately preserves and demonstrates the court's prejudiced demeanor and actions and should be grounds enough for the court to step off the case on appearance grounds. The defense would admit a copy of the recording at the recusal hearing. Footnote 2. If by rule or practice ordinary assignment to the same judge is adopted, there should be a declared policy permitting the judge freely to recuse himself or herself in a particular case, whether or not formally disqualified. The Massachusetts legislature also has recognized through passage that a judge who considers poor adverse findings against a defendant through plea negotiations should not sit on a trial litigant. At the option of the defendant, the trial may be before a judge who has not rejected an agreed recommendation or dispositional request made by the defendant pursuant to the provisions of Section 18 of Chapter 278. I wonder if they have to write that out like that or if they just choose to. Random question, sorry. Review in such cases may be had directly by the appeals court by appeal, report, or otherwise in the same manner provided for trials of criminal cases in the Superior Court. The legislature has provided a blanket veto to the defense where such information has been tendered pre-trial. In the circumstances at bar, a judge who has rejected the defense request for release and found her dangerous and unfit, sitting in pretrial judgment of a defendant, should not handle the trial of this matter. Judge McCarthy Neiman should recuse herself from the trial and any further substantive pretrial proceedings. Findings of dangerousness and parental unfairness, when viewed in conjunction with ex parte communications, personal accusations against counsel, and the judge's own extrajudicial interests, all combine to demonstrate that this court has prejudged critical issues central to this case. Continued participation, quote unquote, might cause a reasonable observer to doubt the judge's ability to approach subsequent proceedings impartially. I agree. I'm a disinterested third party, and I find her to be very biased. Roman numeral 2, personal and economic interests creating an appearance of bias. Basic internet research shows that Judge McCarthy has resided in the town of North Andover for approximately 25 years. Public real estate records indicate she is a listed homeowner in the town. She was the founder and principal of the law offices Kathleen M. McCarthy, a criminal defense firm in North Andover, Massachusetts, and is listed in Massachusetts Lawyers Weekly, April 29, 2020, as a former sole practitioner in North Andover from 1997 to 2018. In adjudicating the alleged dangerousness of Miss Fitzsimmons, a fellow North Andover resident, in a North Andover incident, the court inevitably had to consider the safety of herself, her own family, and former colleagues that work or live in the town. As a taxpaying resident, the judge has a vested interest in the financial security of the town and its reputation in the Commonwealth. On the unique facts of this case, sorry, where was I? Oh God, where was I? On the unique facts of this case, one North Andover police officer, Patrick McCarthy Noonan, footnote 3, discovery documents provided by the Commonwealth relative to Noonan's training list has full name as Patrick McCarthy Noonan, quote unquote. It is unknown and undisclosed by the court whether there is a family relationship. Okay? That's what we're dealing with on this thing. So where was I? Okay. On the unique facts of this case, one North Andover police officer, Patrick McCarthy Noonan, shot and almost killed another North Andover police officer, defendant Kelsey Fitzsimmons. The police immediately adopted and believed the story of the shooter officer and never sought to interview Miss Fitzsimmons, who fought for her life for 53 days in Massachusetts General Hospital. So it was 53 days, not 5 months, sorry. Know where I got the 5 months, but anyway. The case involves only these two officers as percipient witnesses with no body cameras video, because it's not 2026, and why would they have body cameras? I mean, what are we doing here? It's like, I didn't even realize there were still police departments without body cams. Did we not learn anything from any of the cases we've seen in the last 5 to 10 years? Mainly George Floyd, cases such as that. For the love of God, it should be required at this point. It should be a law that all police officers have to wear body cam footage. Just, it is what it is. Every police officer in every police department, in every city, in every town, in every county, of every state in the United States of America. Simple as that. Then nobody gets to choose, right? Let our taxes go to something that can benefit both the people and the police. It's disgusting that these police departments do not have body-worn cameras yet. I mean, what the fuck? Are we living in the dark ages still? It's insulting. The case involves only these two officers as percipient witnesses with no body camera video. The defendant has potential civil claims arising from the conduct of governmental actors in this case, claims that could foreseeably expose North Andover to substantial financial liability. Municipal tort liability directly implicates municipal finances and taxation, and as a resident property owner, the judge has an economic interest that could be affected by the outcome of this criminal trial. Such an interest is disqualifying where it quote unquote, might cause a reasonable observer to question impartiality. I like how he keeps throwing that reasonable observer statement in there every chance he gets, because it's true. And these judges, I believe she is an elected judge. I'm pretty sure. I'm not positive, but I'm pretty sure. Another Essex Superior Court judge, Kristen Buxton, recused herself in similar circumstances as a taxpayer in the town of Ipswich in the matter of Capithorne et al. V. Town Manager. Capithorne was a taxpayer, and Judge Buxton, an Ipswich taxpayer, recused herself, noting an appearance of impropriety, seeking to, quote, ensure the greatest possible public confidence in the court's independence and impartiality. She recused herself due to her ties with the town. She stated, quote, the Code of Judicial Conduct, Supreme Judicial Court rule, sets forth that judges should avoid both impropriety and, quote, the appearance of impropriety, end quote. This is to ensure the greatest possible public confidence in their independence and impartiality. As I am a property owner in the town, and despite no actual conflict, there may be an appearance of conflict, end quote. The appearance of impartiality is compromised when a judge sits in judgment over a case where the outcome may affect her own municipality's financial exposure. Judge McCarthy Nyman should mirror Judge Buxton's decision and withdraw to avoid the appearance of lack of impartiality. Roman numeral 3. Ex parte communications with probation concerning a pending matter. This is what it just blew me away. I mean, my head exploded when I read this. Undersigned counsel has recently been informed that Judge McCarthy Nyman had an ex parte and undisclosed conversation with Assistant Chief Probation Officer Jeff January on September 10th, 2025. That's the day before her hearing about the scram testing, where she lost her shit. Remember that? This conversation occurred the day before the court sua sponte revoked Miss Fitzsimmons' bail and returned her to custody, cut off defense counsel, invited objections from the Commonwealth, walked off the bench when counsel vilified ACPO January in open court, and was visibly shaking and angry. Sua sponte is a spontaneous decision without any kind of hint that it's going to happen. She just does it spontaneously. Ipsy dixit, because I said so. Counsel was informed by ACPO January and his attorney that Judge McCarthy Nyman came to his office unannounced the day prior to this hearing. She sought to investigate the status of Miss Fitzsimmons' compliance with probation terms and was informed by ACPO January that there was no violation. ACPO January recalls that he discussed the fact that he had email communications with undersigned counsel, which appeared to upset Judge McCarthy Nyman. And why wouldn't he? It's that counsel's client that January's dealing with. So why wouldn't he have emails and communications with Timothy Bradle, the Silver Fox? I mean, come on. This is totally inappropriate. And she should suffer repercussions for this. This is unacceptable behavior on the part of a judge. Unacceptable. And it makes you wonder, how many times has she done something like this? And good for January for standing up for what's right. Because you'll find out. I mean, it's disgusting behavior for anybody, but for a judge, are you flipping kidding me? Get her out. When ACPO January mentioned that his emails favorable to the defense were likely attached to the motion filed for relief, McCarthy, Nyman, J for judge, I guess, abruptly left ACPO January's office. There was no legal justification for the court visiting his office and conducting its own investigation outside the presence of defense counsel, off the record and without subsequent disclosure to the defense. Did she really think that January wasn't going to say anything? Because if he doesn't say anything, then he could be in trouble too. Because he would be showing his participation in the situation, even though he's not actively participating. If he doesn't report it to somebody, he's participating in it. These ex parte communications concerned matters bearing directly on the defendant's liberty, which was at stake, unbeknownst to defendant, the very next day. Such conduct directly violates Rule 2.9 prohibiting ex parte communications, where a judge receives information outside the adversarial process and then presides over related proceedings. Not related, I mean directly connected to the proceedings. I mean, the proceedings are in regards to the scram testing. The appearance of impartial adjudication is irretrievably lost. Yeah, good word. Roman numeral 4. Personal embroilment with probation and defense counsel. Undersigned counsel was recently informed that following the September 11, 2025 hearing on the emergency motion for relief, McCarthy-Neiman judge filed a complaint against ACPO January arising from this case. This is despite her unclean hands engaging in ex parte conversations in the probation office. Upon information from ACPO January's attorney, the complaint filed by McCarthy-Neiman, the judge, included accusations of defense counsel, quote-unquote, colluding with probation. As a result, defense team members are now supporting witnesses for ACPO January against the judge in this complaint that directly stems from this very case. So, how do you think she's going to feel about anything Tim Bradel has to say in this trial? She's not going to let him speak, and if she does, everything is going to be overruled or sustained on the Commonwealth's side. I mean, how can she be impartial at this point? She hates him. She has nothing but disdain for Tim Bradel. It's quite apparent. It's disgusting. As a result, the complaint itself is strong evidence of the court's actual bias against undersigned counsel and or Ms. Fitzsimmons. At a hearing on the ACPO January probation matter, undersigned counsel would attack this court's position and credibility and assert that the court's complaint is false, baseless, and merely dissatisfaction with an undesired viewpoint from probation. She didn't get what she wanted, so she's acting out. And it's what she's saying is not true. What she's claiming is untrue. Literally lying. What kind of morals does this judge have? None that I would want to be faced with if I was a defendant in her court. Disgusting. In fact, counsel would also assert that ACPO January at all times acted fairly, truthfully, and professionally. That's why she was so pissed off when Tim Bradel said that January was in the court and wanted to testify. And he had some questions for January. And she can't deny that, so she had to let January take the stand. But she was a raging bitch to him. She was so rude to him. It was disgusting. The behavior she showed was disgusting and vile. That's all I can say. She's a vile human being. She has no place in the justice system. Nowhere. Not even as a bailiff. In fact, counsel would also assert that ACPO January at all times acted fairly, truthfully, and professionally. Mr. January did everything that he could to accommodate Ms. Fitzsimmons' disability, unlike the court itself, and deserves praise and the full support of the probation department rather than an assault on his reputation. Whew. Now you're telling me that Kelsey would get a fair trial after this butt lashing by Bradle? No way. Not on your life. Further, the court's complaint is proof that the court's foray into ex parte investigation before the hearing simply didn't produce the desired information and resulted in the court vilifying ACPO January the next day at the September 11th hearing without any cause whatsoever. Like a little kid throwing a frickin' tantrum. In addition, and perhaps most compelling for a recusal, the fact that the court did not disclose this complaint to counsel for Ms. Simmons Ms. Fitzsimmons is strong evidence that the judge's bias and lack of impartiality. A judge who has entered the fray, particularly by leveling accusations against counsel of record and court employees who provide good faith assistance to defense counsel, cannot thereafter preside without creating an appearance of partiality. The court must recuse. The only way this could be better is if he did that like last sentence in all caps. Roman numeral 5, outstanding questions created by the court's conduct. Based on all of the foregoing, many questions have been raised that create a scenario where the judge's impartiality might reasonably be questioned. Answers require an evidentiary hearing to obtain facts that would likely show that her impartiality is compromised. The questions are including, but not limited to, the following. 1. Is the judge related to Patrick McCarthy Noonan? 2. Why is the judge covering every hearing on this case through the trial? Is there a written order to that effect? 3. Why did she repeatedly leave a civil session to cover this matter? 4. What specifically is in her complaint to the probation department concerning ACPO January's actions? 5. Why didn't the judge disclose the existence of a probation complaint involving the defense on Ms. Fitzsimmons' own criminal matter? She has every right to know. 6. Why did the court have an ex parte meeting with ACPO January in his office? Why didn't the judge disclose the meeting and comply with the Code of Judicial Conduct? Did the judge use any inside information obtained against Ms. Fitzsimmons? And that's a very valid question. And she should be made to answer that, whether she gets recused or not. She should be made to answer every single one of these questions. In person, verbally. And number 8. Why is defense counsel's advocacy perceived by the court as quote-unquote manipulation or quote-unquote collusion? Why is the court using such descriptives which are indicative of bias? Cumulative effect. The SJC has repeatedly emphasized that recusal analysis must consider the totality of the circumstances, even where individual factors might not compel disqualification in isolation. Their cumulative effect may do so. Here, the combination of negative pretrial findings, a personal economic interest, ex parte communications against defendant and counsel, prejudicial findings, and personal entanglements with probation and counsel would leave any reasonable member of the public to question the judge's impartiality. Public confidence in the judiciary requires recusal. Relief requested. Wherefore, the defendant respectfully requests that the court grant an evidentiary hearing, order the recusal of Judge McCarthy Niemann, reassign this matter to a different judge by a means of reassignment not involving Judge McCarthy Niemann and grant such other relief as justice requires. Yeah, she shouldn't even have a say in who takes her place. Dated February 8th, 2026, respectfully submitted. Mm-hmm. Yeah. I mean, you can't, she just can't. Just 1 second, okay? God, I look washed out. I look terrible. Sorry. Okay. So, what does anybody think about that? And the reason why I say that she finally gets a victory is because this happened the very next day. That was submitted on February 8th, right? Okay. The very next day, um, sorry, just 1 second. Okay, this isn't the actual court document, but it basically quotes what the court document says. So I'm just going to use this so that we can get going, get it done. Actually, 2 days later, 2/10/26, endorsement on motion to recuse Judge McCarthy Nyman and request for evidentiary hearing is denied as moot. The judge is scheduled to sit in another session during the period of the remaining pretrial and trial of this case and was not specially assigned to this matter as the motion inaccurately assumes. Judge Fraser, Honorable John C. The actual court document says a lot more than that, and I want to see if I can find it because that was kind of just disappointing, to be honest with you. This is a statement that Timothy Bradel put out on February 10th, 2026, for immediate release. To all media outlets, please direct all inquiries to Attorney Bradel. Please do not attempt to contact the Fitzsimmons family. Regarding result of motion to recuse Judge McCarthy Nyman. The defense team for Kelsey Fitzsimmons is pleased to release today's decision from the Chief Justice of the Superior Court, issued just 1 day after the filing of our comprehensive motion seeking the recusal of Judge Kathleen McCarthy Nyman. In the court's order, the Chief Justice determined that the recusal motion was moot in light of some unspecified intervening administrative action, noting that, quote, the judge is scheduled to sit in another session during the period of the remaining pretrial and trial of this case, end quote. As a result, Judge McCarthy Nyman will no longer preside over the pretrial proceedings or the trial of this matter. While the order does not specify the timing or source of the administrative assignment, the practical effect is clear. Judge McCarthy Nyman will not continue to sit on this case moving forward. This outcome directly addresses the core concern raised in the defense's motion, namely the necessity of preserving the fairness, impartiality, and appearance of justice throughout the remainder of the proceedings. The defense team appreciates the court's prompt attention to these issues and remains committed to vigorously defending Ms. Fitzsimmons' constitutional rights as this case proceeds. We will continue to advocate for a fair adjudication grounded in due process, transparency, and the rule of law. Now, isn't that convenient? Isn't that coincidental? I mean, it can't get any better, right? I mean, it's like, wow. And it just so happened the very next day by the Chief Justice, mind you. I have to say that I'm thinking there's a little more to it. That's just my own personal opinion. I have no proof of that, but I've got to wonder if her ass isn't going to get handed to her by her boss. And it should. It should. The audio recording alone of the hearing on September 11th is disgusting. It makes you physically ill to listen to the way she behaved in that courtroom. It was disgusting. And when Timothy Bradel originally appealed her decision to put Kelsey back in jail pending the trial, it just didn't make the impression that I think Timothy Bradel was hoping for. You just can't put that kind of behavior and that kind of tone in writing. It's got to be heard. There's just no other way to relay it in the context that it was given without playing the audio. Or even video if you had it, but there's no video allowed in the courtroom, so the next best thing was audio. But if you don't at least hear the audio of that hearing, you have no idea the underlying tension that was in that courtroom that day, caused by the judge and her tone when speaking to Kelsey Fitzsimmons and her attorneys. It was disgusting. I can't even, there's no way to put into words what it sounded like and how it was taken and how it was meant. It wasn't taken out of context by any stretch of the imagination. It was taken how it was delivered, and it was delivered as just vile behavior. There's no other way to put it. It is what it is. And she can't deny it. It's on record. And there are recordings of it. It will never go away. It's always going to be there. The internet is forever, my friend. And that behavior shouldn't go away. I mean, the behavior should go away, but the recording of it should never go away. It should be played for her in front of a disciplinary council or whatever they do, whatever they're called. She should be made to listen to it in front of a disciplinary committee while they come up with some sort of punishment for her behavior. That's just my personal opinion. I know it'll probably never happen because I know judges can basically get away with anything in their courtroom. They have no legal bindings. Basically, they can do whatever, whenever, however they want in their courtroom. It's their courtroom. But the behavior was repulsive, just repulsive. I don't think, it doesn't matter what she does at this point, I would never have any respect for her. Not as a judge, not as a lawyer, probably not even as a fellow human being. Especially not as a mother or a fellow woman. She is definitely not empathetic in any sense of the word. And just to see another woman treat another woman that way is unimaginable. I'm not saying the female judges need to show female defendants special treatment by any means. I don't mean that, but most women are empathetic towards other women. They can't help it. It's just in their genetics. It's in their chromosomes. And she doesn't have that. I don't know if she doesn't have kids. I don't know if she's just a bitter bitch. I don't know, and I don't care. There's no room for it in the justice system. You cannot bring that kind of shit into the courtroom. And she did. Not just one time either. She did it repeatedly. And she didn't even try to hide it. It was disgusting. I just can't even tell you how disgusting it is. It makes my skin crawl to think of her behavior that day. And now that I know that she went to January's office and commenced an ex parte meeting and tried to do her own little side investigation into Kelsey Fitzsimmons, are you fucking kidding me? Who the hell do you think you are? I know you think you're above the law, but you're not. You can just control what's in your courtroom, but you cannot step on Lady Liberty's toes and say, fuck the Constitution. Fuck her civil rights. You just can't do that, because that's when the public gets angry at you. And you don't want the public angry at you, especially if you're an elected official. And I believe that she is. So there's that. Anyway, let's move on. Sorry about that. Let's real fast do the Aaron Spencer thing, because I don't think his is very long. I don't even think they have a date. I think there's just a notice of a stay because the attorneys and the judge are having a hard time coordinating dates that they can start this trial on and do it straight through, not have to chop it up and do it different times. They want to do it streamlined. So they're having a hard time. Plus, he needs to be brought current on all the debauchery and bullshit that's been going on in this case. I have to tell you, I've been following true crime and whatnot since probably 9th grade. Probably since I was in 8th or 9th grade. And I have never in my life been so disheartened and discouraged in our legal system as I am today. I thought maybe Massachusetts was a rare and once in a lifetime type situation. I never in my wildest dreams thought that I would come upon case after case after case in state after state after state where this kind of shit is happening. It's just, it breaks my heart because I really, really believed in our justice system. I thought we had the best the world has to offer. And we made criminals pay for the crimes they commit. And now I have to wonder how many people that are in our overcrowded prisons are actually guilty as charged. Is it a half and half? Is it a 60-40 or 40 or 40-60? I mean, and we'll never know. We will never know. There's always going to be corruption, but I never thought in a million years that it would be this blatant in so many courtrooms. It's really, really disheartening. And I have a hard time stomaching it a lot of the time now. I mean, it's just, I don't know how to describe the feeling it gives me, but it just, and you can't turn your back on it and act ignorant of it, because then it will only get worse. You have to keep your eyes on, what the fuck happened? You have to keep your eyes, you have to babysit them. Otherwise, who knows what the fuck will go on. I mean, this is with people paying attention. This is with world eyes from all over the world watching these cases with us, and they still do it. Could you imagine what it would be like if nobody was watching them and keeping track of their bullshit and making them be accountable, or try to make them be accountable? I mean, it's insane. I can't imagine what our justice system would look like if we didn't have access to these cases. Like some courtrooms still refuse to give access to the media, but they're getting better. Why is this not coming up now? God damn it. Why is it always something? I tell you, it's infuriating. Okay, so you can start. Yeah, I know that. Okay. I know all this. Why is it telling me to do? I just looked it up this morning, so I'm not sure why it's having issues now. Now of all times, right? Maybe it's because my VPN is on, you think? I'm probably frozen right now because I'm using the same browser as I am in StreamYard, and StreamYard is just all kinds of fucked up right now. So if I do something on the same let's try this again, shall we? My stomach's making all kinds of weird noises. I'm not quite sure why. So anyway, I'm sorry to have gone off on that rant, but it's just it's very, 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 and that's why I knew I could never be a lawyer when I was in school and trying to decide what I wanted to be when I grew up, because I knew that if I was to be a lawyer, I'd want to put guilty people away and monsters away. I'd want to, convict monsters, but I would never, ever, ever be able to prosecute somebody who I felt was innocent. I just couldn't do it. I don't care if it was my job or not. I couldn't do it. And so I thought, well, I can't be a lawyer then. I can't switch from case to case. Oh, this guy I think is innocent. I'm going to be a defense attorney this month. And oh, I think that guy's a monster. I'm going to be a prosecutor this month. You can't do that. So it's like, So I knew I could never be a lawyer. A police officer, I really, really, really almost. But then I thought, they do the grunt work, and it's like, is that worth it? No. It's a thankless job, right? So why would I want to do that? What is going on here? Oh my God. It's really annoying. I'm not quite sure what's going on here, but let me see. We're going to try something else. I just looked it up before I took my husband to the surgery, to the hospital, because I knew I was going to be coming back and doing this, and I wanted to be able to do it in a streamlined manner and get it done, and now it's giving me shit. It's like, fuck. It's always something, right? Okay. I'm not sure what's going on here. Sorry, you guys. I might have to go through my Pacer account. Just one second. Stomach is making so many weird noises. It's crazy. I'm sorry about this. God, this pissed me. Now I'm going to have to edit my fucking video. God, nothing can ever fucking go smoothly for me. You know what? We're just going to cut our losses with Aaron Spencer right now. We're just going to go right on to the Alexander brothers. Because I just can't. I don't have the patience for this. It's just so frustrating. So we're just going to go, move on, cut our losses. I'll do a video of that later, I guess. So let's move on to bigger and better things, shall we? Not bigger and better things, you know what I mean. Let's just move on to something that most likely is going to work for me. Okay, I don't know who all has seen my my video, my videos on the Alexander brothers, the how can I describe them? The narcissistic pieces of shit that from Florida who were raised with a silver spoon in their mouth and did some horrible have been doing some horrible things for the past decade or more. That's all I can say about that. These guys are just a whole nother level of predator, is the best way to put it. They have been preying on young women and young girls for over 10 years. Since high school, they've been doing it. And it's beyond disgusting, the things that they've been doing. But their trial is not in district court or state court. It's in the federal courts because it involves human trafficking charges and such the like. So their trial is not being streamed or televised or anything. So I'm having to kind of follow different different journalists that are covering the trial and just kind of give, you know, either daily or weekly reports that way. But I have not been able to, because their trial started the same day that Aaron Spencer's trial was supposed to start, which was what, January 26th or something like that. And so their jury selection took place that first week, or that first half of the first week. And then they started the trial, but that's when, you know, my husband got hurt or whatnot, and it's just been kind of hanging on by the skin of my teeth since. So I looked up some overview of the first and second week of the trial, and then I looked up the Epstein files that they were mentioned in, and they were mentioned. It's unbelievable, but they were mentioned. So, without further ado, we are going to go over these two recaps of the first 2 weeks of the trial. Did I just lose you guys? Oh my God. No, thank God. What the fuck? Okay, sorry about that. Why is this not? Did it say it or not? What is going on here? So I'm starting to get really irritable because of this shit. My dog's about ready to lose her shit. So if I mute you, that's why. Okay. That's as good as it's gonna get, I guess. Can't complain. Right? Beggars can't be choosers, right? Okay. So here we go. Alrighty. Does that remind you of the Karen Reed trial? It does me too. Okay. The first week of the Alexander Brothers federal sex trafficking trial featured opening statements, witness testimonies alleging incapacitating and essaying, and the introduction of graphic evidence. I couldn't imagine being a juror on a trial like this. Overview of the trial. The trial began on January 27, 2026, in Manhattan Federal Court with Alon, Oren, and Tal Alexander facing 12 federal counts, including conspiracy to commit sex trafficking by force, fraud, or coercion, and inducement to travel for unlawful sexual activity. The brothers, aged 38 and 39, two of them are twins. That's why. 38 and 39 have pleaded not guilty and have been held without bail since their December 2024 arrest in Miami. Prosecutors allege the brothers used their wealth, social connections, and luxury lifestyle to lure women to destinations such as the Hamptons, Miami, and Manhattan, where they were allegedly incapacitated and essayed. Opening statements. Prosecutors portrayed the brothers as predators masquerading as quote-unquote party boys, emphasizing that they used luxury accommodations, flights, incapacitating components, alcohol, and sometimes brute force to carry out assaults. Assistant U.S. Attorney Madison Smizer described the brothers as quote-unquote partners in crime who celebrated their crimes and targeted women repeatedly over more than a decade. Defense attorneys countered that the sexual encounters were consensual, framing the brothers as ambitious, womanizing young men engaged in hookup culture, and questioned the credibility and motives of the accusers. Victim blaming, basically. Witness testimonies. Several women testified under pseudonyms. Katie Moore described meeting Alon and Tal Alexander at a 2012 NBA Finals watch party at actor Zac Efron's apartment. She testified that after taking MDMA and drinks, she blacked out and later woke up naked in a bed with Alon standing over her. She alleged repeated SA and that Tal Alexander did nothing to stop it. Maya Miller recounted being invited by Tal Alexander to a Hamptons weekend in 2014. She testified that she was incapacitated and essayed in a Sag Harbor mansion, including being cornered in a shower. Defense attorneys questioned her actions after the alleged assault, including her communication with Tal and her social media activity to challenge her credibility. It's not uncommon for women to try and make something more of it to justify what they did, because they feel like they have to justify what they did. So they try to make some kind of relationship out of this disgusting event so that they don't feel so dirty, because they know that people most likely won't believe them if they did come forward. So they try to make it and believe, they try to tell themselves and believe that, it's not that bad, and, I can be friends with them and maybe date him, and, maybe it didn't happen like I'm remembering it, or what, maybe he didn't mean for that, for me not to be able to remember. You know what I mean? They may just be their way of coping. Amelia Rosen, which is a pseudonym, was introduced via a 2009 video showing Orrin Alexander allegedly having sex with her when she was 17. She testified that she had no memory of the encounter until contacted by the government, and described the experience as, quote unquote, one of the hardest moments of her life. Bella Koval testified about a 2016 Hamptons trip where she alleged Orrin Alexander incapacitated and raped her. She described feeling trapped and losing control of her body, with Alon present during the incident. Evidence presented. Prosecutors introduced emails, photos, and videos documenting the alleged assaults. One email from Tal Alexander referred to women as, quote-unquote, cheap hookers coming to the Hamptons, and a video recorded by Orrin allegedly showed sexual activity with the minor. Jurors were shown these materials privately with headphones for audio, and some jurors took notes during the viewing. Defense strategy. Defense attorneys focused on challenging the credibility of witnesses. Victim blaming. Highlighting inconsistencies in testimony, social media activity, and the lack of corroborating medical or toxicology reports. They argued that the encounters were consensual and that some accusers were motivated by regret or potential financial gain. I don't think any of these women are asking for a fucking dime from these guys, because I don't think they want their money. It's dirty and disgusting. Key takeaways. The trial highlighted a stark contrast between the brothers' public personas as wealthy, party-going real estate brokers and the allegations of systematic sexual exploitation. Graphic evidence and emotional testimonies set a tense tone for the proceedings. The first week concluded with the prosecution presenting evidence related to sexual exploitation of a minor, setting the stage for the second week of testimony. The trial is expected to last at least a month, with additional witnesses and evidence to be presented in the following weeks. So there's that. Now let's see the second week. It's disgusting. I just can't. And one of them was engaged when they were arrested, and actually had the audacity to ask the judge if he could be released on bail because his new wife was going to have a baby. Well, you know what? You didn't care enough to fucking not partake in this bullshit. You didn't care enough about her or your baby to, not partake in this. So why should we empathize with you now? Fuck you and your motion. Because this judge is like a no bullshit judge. She's awesome from what I've heard and seen so far, or read and heard so far. The second week of the Alexander brothers sex trafficking trial focused on witness testimonies, incapacitating related evidence, and intense cross-examinations highlighting allegations of essays and the use of luxury travel to lure victims. Key testimonies and allegations. During the second week, prosecutors presented testimony from multiple women alleging SAs by Orrin Alon and Tal Alexander. Witnesses described being incapacitated or overpowered or rugged during encounters at luxury homes, Hamptons rentals, and party cruises. Notable testimonies included Katie Moore alleged she was incapacitated and raped by Alon Alexander in Manhattan in 2012 after a party at Zac Efron's apartment. Maya Miller testified that Tal Alexander raped her in a Hamptons beachfront rental in 2016, describing attempts to protect herself and her friend before being assaulted in a shower. Amelia Rosen, a 17-year-old at the time, testified about a video showing Orrin Alexander essaying her, which she had no memory of until contacted by the federal authorities. Could you imagine? That'd be like getting hit right here in the solar plexus. Bella Caval alleged she was incapacitated and raped by Orrin Alexander in 2016 during a Hamptons weekend, describing being unable to move after consuming a drink and being assaulted with Alon's involvement. Rhonda Stone recounted being assaulted by Orrin and Alon on a 2012 party cruise, losing memory after consuming a drink and later realizing she had been SA'd. Evidence presented. Prosecutors introduced emails, text messages, and social media exchanges showing the brothers coordinating the acquisition and use of incapacitating substances, such as, and it gives the mentions 5, to incapacitate women. These communications were used to support the government's claim of a decade-long sex trafficking conspiracy, often involving promises of luxury travel, private chefs, and exclusive experiences to lure victims. Photographs of luxury properties and resorts in the Hamptons, Aspen, Las Vegas, and the Bahamas were shown to illustrate the quote-unquote material benefits offered to victims, a key element in proving sex trafficking. Defense strategy and cross-examinations. The defense challenged the credibility of witnesses, highlighting inconsistencies in their accounts, social media interactions, and post-incident behavior that suggested consensual encounters. Attorneys aggressively cross-examined witnesses, questioning details such as clothing, timelines, and actions after the alleged assaults. They also sought to downplay the impact of the Epstein-related documents, with a motion for mistrial denied by Judge Caproni. Defense arguments emphasized that the brothers' interactions with the women were part of a dating or hookup culture, asserting that any sexual activity was consensual and later regretted. Procedural highlights. Judge Valerie Caproni instructed jurors to disregard lawyer questions as fact and denied a mistrial request related to Epstein files. Jurors were individually questioned about exposure to outside information to ensure impartiality. The trial continued to focus on establishing the conspiracy, with prosecutors presenting evidence of coordinated incapacitating use and SA across multiple locations. The second week of the Alexander brothers trial was marked by emotional and detailed witness testimony, corroborated by digital communications and luxury property evidence. The defense focused on credibility challenges and consent arguments, while the prosecution emphasized the pattern of luring, incapacitating, and assaulting women. The proceedings highlighted the complex interplay of witness accounts, digital evidence, and legal strategy in a high-profile federal sex trafficking case. So now I want to show you the Epstein, where they are on the Epstein, in the Epstein files. This really kind of, I don't know why it shocked me, because, they're highfalutin, ballin' guys, but I wasn't expecting it, I guess you could say. I'm not going to read anything about Trump or anybody because they aren't in, they have nothing to do with this case. So I'm not out to hurt anybody like that. These guys are just pieces of crap, and it needs to be brought to the public's attention just what kind of animals they are. Sammy Sosa, that just breaks my heart. I mean, Jesus, what's this working? Now Joe Rogan is on the list or is in the files. It's like, I don't think there was one person that wasn't privy to this to this shit. Okay. At age 16, while modeling, Collar attended 8 parties at Epstein's New York residence. On one occasion, the caller reported she was essayed by Epstein. On another occasion, 2 twin brothers, Alan and Oran, lured the caller and her friend upstairs, but they escaped back downstairs. Caller stated Oran raped her best friend, and a third brother, Tal, raped a 14-year-old girl named Katie. I'm not even going to say the name. I mean, I just can't believe they put the victims' names in here, but they did redacted the monster's name. Collar named other individuals involved in the big orgy parties with her other young girls and older Victoria's Secret models. I thought there was a little bit more about them, but maybe I was wrong. I guess that's all I saw, but I just thought there was more about the brothers. I'm going to have to keep looking because I'm pretty sure there was more about the brothers than that. But yeah, little girls, you disgusting pigs. All of them. Any of the people that are named in here, if they can prove that these people did any of these actions, they all need to be put on an island with each other and they can do what they want with each other. How's that? Never to be seen or heard from again. That's my feeling. We don't have room in the prisons for them. So put them somewhere where they can be forgotten about. And if they can't sustain life themselves, they die. Plain and simple. You know what I mean? If they cannot start a self-sustaining lifestyle on a deserted island as a group of people, then they don't deserve to live. Either figure it out or perish. That's my opinion. I don't care who it is. If it happens to be the big guy in the White House or Joe Rogan, I don't care. If there's evidence of them partaking in any of these activities, they need to be all rounded up and taken to, hey, how about Epstein's Island? And let them figure it out. Let them figure out their own hierarchy, their own government, their own food supplies, Let them figure out how to sustain life. And if they can't, they perish. Then we don't have to carry out a death sentence or capital punishment, but we don't have to live in the same cities and states and breathe the same air as these animals. They're off on their own, on an isolated island. They can't get off of it. If they try and swim, they get eaten by sharks. Whatever. But then we don't make our prisons even more overcrowded with this bullshit. We don't give them any more attention, and they're out of our lives and out of our sight and away from our kids and away from us, away from our societies. And yet we're not paying to house them and feed them and keep them locked up. They're on their own. If they figure out a way to get off that island with no contact with you would have to have guards on the island, I guess, or guards patrolling the island on yachts or boats, or maybe have a Navy vessel stationed off the island so that they can make sure that nobody who knows where this island is and has connections with these people come and try to, help them escape. That can all be figured out. I mean, I don't have a doubt about that. But just be done with them. We they would have to stand trial. Obviously, you can't just assume they're guilty. Everybody's innocent until proven guilty beyond a reasonable doubt. But once they're found guilty, they're gone. They can do whatever they want with each other out there. If they want to have kids with each other, and then we would move in and remove the children, obviously, they wouldn't be allowed to violate them. But if they want to violate each other, let them. More power to them. But if they can't figure out a way to work together and figure out some kind of governing body and figure out a way to self-sustain life and grow crops and feed themselves, they perish. And our hands are clean. We had nothing to do with them perishing. They did it themselves. They weren't able to conform to life out there, and they weren't able to figure it out. And too bad, so sad. Sayonara, baby. And then we don't have to overcrowd our prisons with the riffraff, and we don't have to worry about them getting out on a fucking technicality and being around our kid neighborhoods, and they're gone. We don't ever have to see or think about them again, ever. They can have their own little cemetery so that when they die off, they can bury each other, and eventually they will all be gone. Because if they do procreate and have kids, we move in and we take the children when they're very young, like infancy, and we give them to deserving families that are unable to have kids for some reason or another. Give them a good home and be done with them. And after so many years, they'll die off because they're not reproducing and staying on the island. You see what I'm saying? So they'll eventually all die off. And sure, eventually there will be just one or two left. And yeah, it'll be hard. But life's not easy. And you didn't make it easy on any of your victims. So why should it be made easy for you? Just because you have money and status? No, thank you. I'll pass. Yeah, so like I said, I will try and find a way to get the Aaron Spencer court document that I was looking for. For some reason, I think the Arkansas Judiciary website is either down or down for maintenance or something. So yeah, I will just record a video for that and post it later. So, anyway, I hope you guys all enjoyed this video, this live. And sorry about the hesitation in the middle. I'm not going to edit it, I'm just going to let it roll. But I do appreciate all the views on my short video clip about the judge in the Aaron Spencer case being recused. That was just a celebratory moment that I just had to, just say something. And I was getting ready for work. I really didn't have the time. So that was that. But I appreciate all the views. And yeah. So I hope you have a good rest of your Friday the 13th. Again, don't forget tomorrow is Valentine's Day, and you don't have to spend money to show someone you love how much you love them. You don't have to spend a dime. Just, you'll know when the actions feel right. And you don't have to spend money to make someone feel special on Valentine's Day. So, people that think that they can't afford to have a girlfriend or a boyfriend because for on days like Valentine's Day they can't afford anything, it's that's a scapegoat attitude, because you don't have to have money to be in love and to show the person you love how much you care for them and how much they mean to you. So, yes, you should definitely show it in your actions every other day of the year. I'm not saying you just show it, them on February 14th or Christmas or whatever, but um, it's always nice to have like a little special day here and there throughout the year to get out of your norm. You know what I mean? And yeah, and you don't have to spend money to do it. You can have a little picnic in the backyard with a fire pit. I mean, there's just so many little ideas that I think are truly special, probably more special and romantic than going to an expensive restaurant in a suit and spending all kinds of money on some fancy meal that you would probably never eat at any other time. Yeah, no. I'd rather have like a little fondue picnic out by the fire pit or out by a lake at night with candlelight, fly kites and have a picnic, early picnic dinner. I mean, just there's go on a bike ride and a picnic. I mean, there's so many little things that you can do for free that tell somebody just how much you love it. Tell somebody you love them just as much as if you were to take them on a private jet to Paris for dinner. It's not the amount that they spend on you, it's the thought that goes into the activity. And anybody can take you to a fancy restaurant and let the restaurant basically do it all for them to show you how much you mean to them, or they can do it for you, which to me shows me even more how much I mean to them. So there's that. Anyway, again, have a good weekend. If I don't go live again tonight, like I said, I'm probably just going to do a little video about the Aaron Spencer update and trial update. And then there is another case that I've been watching that I wanted to do a video on. But in case I don't get that done tonight, on Monday, it's the cases. I mean, the trial's over. Basically, today they were doing their charging documents. How the attorneys have to agree on the charging documents and the verdict slips and stuff. But go back and watch it. It lasted, I think it was like 2, maybe 3 weeks long. Not a very long trial. But talk about a modern day lynching. Lisa Lott is the judge, and it takes place in Cook County, Georgia. No, Athens. I can't remember which county, but it's Athens, Georgia. A little hick town, a little courthouse. And it just goes to show you how stuck some of these states still are in their way of thinking, how backwards they are still, and it's disgusting. It really is. I'm ashamed to watch a lot of it, and it just makes my blood boil so much that it's like I have to take a break from it because it's so egregious and so in your face. So yeah, if you get a chance, tune in on Monday. I think they're going to do closing arguments on Monday. But if you are interested in watching the whole trial, don't watch Monday, because if they do come back with a verdict, I don't want you to just say, oh, and not watch the trial. You have to watch the trial. It will blow your mind. If you thought that Judge Canoni and the Massachusetts Norfolk County DA's office and the Massachusetts State Police were bad in the Karen Reed case, you ain't, or Judge Elmore in the Aaron Spencer case, you ain't seen nothing. And that is not a lie. That is not overstating it by any stretch of the imagination. And the defense counsel did make a motion for the judge to be recused or to recuse herself. And of course, just as Coney did, this heard the made the ruling herself. Uh, there's that, and it's just a swamp. good night. Thank you for joining me. Hope you enjoyed this video, and hope you have a good rest of your Friday the 13th. And I will see you guys soon. Stay safe, stay warm, stay dry, stay happy. And I will see you soon. Bye-bye.